your show for DAO insights and deep dives. The DAO space is really hard to track on your own. There's so much that's going on in this space that a single person just taking a look at it will just find it really difficult to access. But with this show, we speak to some of the best DAO operators and thought leaders in this space, and we are able to keep track of developments and understand what's going on with the space so that you can be savvy as a listener. My name is Abhishek Ajit, and along with me is my co-host Sanavne. Hey Abhishek, how are you?
Hey man, doing good. Looking forward to this one.
Yeah, I think this is one area where we lack. I think we have zero expertise
Yep.
on, so I would be glad to have these gentlemen on the board for this. For this particular episode, we have a couple of people who started a new initiative that's looking to sort out a lot of the existing knowledge gaps and also matchmake with respect to the legal side of things. And I've had the opportunity to interview this one particular person a long time back while I was working for a DAO tool. And it's a pleasure to have him on board again with his partner. We have with us EagleEx slash Francisco Patti, who is an advisor for Polygon and is also part of PolygonDAO. And he also just comes up with a lot of cool, facilitates a lot of legal insights for the bDAO legal, which is pretty neat. And along with him is his partner, Miguel Lucas, who is the partner with him for a new initiative that they've started called the Blockchain Lawyers Group. Hi, guys. How are you doing?
Fine. Thanks for having me here, Abhishek, and it's a pleasure to meet you again.
Hi,
Absolutely.
Abhishek. It's great to be here. Great introduction, by the way.
Yeah, absolutely. So it's a pleasure having you guys on board. Really stoked to figure out what's happening in the whole legal side of things and what you guys are all up to. But before we get to the meat of the things, I think we have to ask an important question over here. What's the best lawyer joke you've heard?
So I'm really the classical lawyer, so I'm not funny at all. I'm sorry, but of course we combat every day, like we fight the stereotypes. We try to be more aligned with the ethos of the industry, and so trying to forget what we are, but I'm not funny at all, so I'm sorry.
I did try to go, I do a lot of venture capital and blockchain and crypto work. So I did try to be a little bit more interesting than a standard lawyer. But even though I think the stereotype just attaches to us and there's nothing we can do, it's the boring type. And no one is very happy when they have to speak to a lawyer. Yeah, myself and Francesco.
Yeah, when they say, you mentioned that you're all boring and stuff. But how do you know that a lawyer is actually lying? It's when other lawyers are actually interested and they're playing around. One thing I wanted to ask is, coming from India, this joke I read from somewhere, so don't play along with that one. Why is there so much hatred for lawyers in the West? I think we get along with Indians a little bit. I think I hear a knock for a lawsuit somewhere down the road, but okay. But why is there so much of an apathy towards lawyers? It seems, especially when you consider the whole crypto side of things, you guys really push the whole frontier of when we have to deal with the government. And in that case, you guys do a lot of good work. But why is there such an apathy towards this profession that way?
So I think that it's, at least in our industry, it's related to the fact that there is a lot of uncertainty concerning the regulation and people do not really know what to do. It is complicated because it's like every project is international, and so you have to basically bear with different kinds of laws. And then it is because like you deal with monetary value, and so like you trigger a lot of rules which are a bit dangerous for individuals, as for instance anti-money laundering and KYC, and therefore like it's really, it could be like dangerous for people that act in this world without being aware about which are the rules. And then the fact is that like the rules are coming, so it's not that we have a legal framework which is perfect, and so everyone tries to influence a bit the legal framework of the future. And so it's very important to discuss about things, to interpret, because I think that lawyers that work in this space are basically in the best position to try the future and to induce like regulators to have the best rules for practitioners and for the industry as such. And so I think that's the reason, and it's really increasing. So I think it was not the case in 2020 after the DeFi summer. It really increased a lot because the crypto growth was enormous. Now we are in the bear market crypto winter, but nonetheless there is more interest than before, and so the regulation is coming.
Yeah, and I guess lawyers in this space are really into innovation, and they just want to foster an environment where that innovation can grow. I hear all the time. I work a lot with startups, and you hear them all the time saying, "Move fast, break things," and that kind of works in a sense. But there are some other areas where it's good to have like an advisor, like myself and Francesco, saying, "Okay," and advising startups has a lot of that. Just okay, there are certain risks. Here are the red flags that you should be attentive to. Take that into consideration when developing your product, when launching. And yeah, we build long-term partnerships with our clients from seed stage till exit. And I think that's the way to go, building a healthy and prosperous relationship with them.
Absolutely, man. I think the sort of work that you guys do is phenomenal. And see, no profession's perfect that way. And in that case, the way in which you want to ensure a safe environment where developers and the community can just work together in harmony, it's amazing. Especially when you take a look at what's happened with the Tornado Cash developer Alexei Pertsev. The community alone cannot do that. There's a lot of work that has to be done by the legal experts, and you really start understanding the value of that when situations get dicey. But stepping back for a minute, what's your stories, by the way? How did the both of you come to get involved in this nice profession, by the way? Why don't you go ahead and start, Eagle?
So I go very fast. I'm a law professor and an attorney here in Italy, and I basically teach in matters concerning digital law and blockchain technology. And I really came into the industry because of two students, which started a crypto fund back in 2020 during the DeFi summer. Things went very well for them, and I got also passionate about the industry. And so I started to access a bit crypto-friendly environments, and I started to deal with the bankless DAO, which was a bit a new concept for everyone. It's a big DAO international, and there I met a lot of people. I founded the legal guild of bankless DAO, where with other colleagues all over the world, I discussed issues concerning law. And then I started also to be a member of Lex DAO, which back then was a very small collection of individuals, like 5, 6, that were there and discuss legal engineering things. And then, yes, I started really to advise. At the beginning, it was a kind of hobby. Then I started to advise crypto projects. I got also this agreement with Polygon, which was, of course, important. I started to work with startups, and therefore I had a lot of contacts and a lot of work. And then I was also involved in something which I think it's very important for the industry, which is the Lex Punk Army, which is an organization which works for the benefit of the industry in granting free access materials and legal educational materials. They do also advocacy, and it was funded by DeFi projects, by Lido, by Curve, and by Yearn Finance. And so I was there from the beginning, and I also worked with them. And it's really a way of being connected to all the rest of the crypto lawyers' work. And it's a lot of fun and a lot of interesting work.
Yeah, it's for myself until the beginning of 2018. I didn't know this, but I was curious, but I didn't know. And then went to do an LLM, which is a master in laws in London. And eventually, in the first day that I was here, I was at a party, and I met this girl who just told me that she was incorporating a startup. She was launching a startup which was doing fractionalized ownership in the blockchain, and that she had received like a 10 million pound investment. And I was like, so what is the blockchain? Can you tell me a little bit more about that? Eventually, I did my dissertation on the regulatory framework of crypto assets in the EU. And then I was fortunate enough, because I went back to Portugal to a leading law firm there. And at the time, there were still are a lot of crypto millionaires flocking into the country to take advantage of the tax exemption on capital gains derived from the sale of cryptocurrency. So the ecosystem grew massively. And there, for the last 4 or 5 years, we've seen a lot of these crypto millionaires acting as angel investors, as founders to new startups, and myself in the venture capital space. I saw a lot of that, but also since I knew a lot about the blockchain ecosystem, I did advise on more regulatory matters, fund incorporation, corporate structuring for DAOs. I've done a lot of that. So that was my background. Now I'm working in London and also at a law firm, and I'm doing the same thing, venture capital and blockchain regulatory assistance for these emerging companies.
Oh, that's pretty neat. Guys come from these different backgrounds in a way, but in spite of this profession being structured for the trad side of things, you had the sort of open-mindedness to come into this space and really want to make a difference with respect to how DAOs are done. It's only very lately that you see the whole legal profession really take an interest and step in the way it's done. What I like about Eagle, you mentioned that this these couple of associations like LexDAO, you have the LexPunk Army and bDAO Legal. I think these are the three main DAOs that kind of have put in a lot of effort to understand how DAOs could traverse the whole legal landscape in a way where communities are able to kind of participate and be a part of the system. But a lot of good work also done by LexDAO lately. They've stepped in and put in a brief for OokiDAO concerning one of their situations. And you have these bunch of enthusiasts that come in and really want to shape how this ecosystem is done. How does your initiative, blockchain lawyers, kind of form from that point? What is the origin story behind it? When you have all these associations, how did you conceive of this group?
Yeah, thank you for the question. I think it's important like to position it ourselves. We spoke before about LexDAO and LexPunk Army. There's also the Bankless DAO Legal Guild. And I think that everyone has a kind of role in the industry. LexDAO is a very good organization to frame like technological solutions, which can basically ease the application of the law. And so it's not only lawyering, it is also like engineering solutions and smart contract solutions, for instance, like incorporating a company through smart contracts. And so if you go there, there is an educational part, there is a part which is more advisory, but it is a very loose organization in which everyone can come and basically spend time, try to lurk a bit, like as it is done in DAOs often. And LexPunk Army has really a role for advocacy in creating this public goods. For instance, you want a DAO agreement, you go on the repository of LexPunk and you find it. You are looking for guidelines to set up, I don't know, a foundation. You can go there and find some first advisory. Very helpful too. What we thought was, and Bankless DAO, just to finish, it's more like about a media. We have a newsletter which is very read, like we have 15K readers, and so it's more giving information about what's happening all over the world. We have also an interview section, and so it's not so much advisory, it's more like discussing legal issues, legal developments all over the world. What we felt was missing in the industry is really like a go-to place if you're looking for a lawyer, someone that can advise you on a professional basis, which is not the case in the other organizations that I've said. Like there, it's more like to learn, it's more like to do something useful for the collectivity of the industry, but it's not like to advise on a professional basis. And so we wanted to create this very strong network of lawyers which are already well recognized in the world, and that can be a kind of corporation that can be chosen by people that want to engage in crypto. And our target are not only like Web3 initiative but also people that want really to engage with the off-chain world. We advise also CASPs for licensing and are always, let's say, open to create a bridge between what we know on the blockchain and the external world, because we think that like also the financial system needs to onboard a bit what is happening on the blockchain. Otherwise, I think that the future will not be bright. So the idea is really to try to increase as much as possible the adoption of the blockchain, and this means also finding out legal solutions that help to do. Like we use social media which are proper for Web3. We use Twitter, we use Discord. We are a gated association, as Miguel will explain. But at the same time, we are on LinkedIn, and we try also to engage like the off-chain world. And now perhaps Miguel can tell you something more about how the association is organized.
No, that's exactly it. I think it's a good point to note that we are a non-for-profit or association. Revenues just come from the membership fees and from any eventual grants that we may apply for. But yeah, we are merely a network. So internally, we are a network within the lawyers that are our members. These are all qualified in the jurisdictions that they are featured in the directory and have relevant prior experience in advising blockchain and crypto matters. So between ourselves, we do have, for example, free advice policy, whereas you can just clear any questions with a member from any different jurisdiction free of charge. We have an informal referral fee policy. So that's how we are trying to monetize the membership. And it's very good to share ideas and share knowledge and past experience, because ultimately that's what we want. We want to better advise our clients in the end. Externally, for potential clients, I think we have a unique selling point, since all of our lawyers have digital wallet addresses. They receive an NFT as part of the membership, so they are part of an NFT membership kind of model. They are part of an NFT gated Discord. They are on Telegram. They are on Twitter. So they are within the ecosystem, and there's a certain certainty for potential clients that these guys can advise properly on that specific issue or on a specific matter that they may have, because they have prior experience and also because they are within the ecosystem. So there's no explanation of key terms or anything like that. They are assured that these lawyers are qualified, and I think that was something that was missing. And myself and Francesco built this organization. We wanted to start really small with 23 members or 25 members from 22, 23 jurisdictions, but we've been receiving an overwhelming amount of requests to join the association. So I don't think we'll be small anymore in a couple of days, but we're trying to vet everyone and to talk with everyone to understand if they would be a good fit for the project.
So this non-profit angle that you have taken, this serves very well in terms of advisory and questions. What if there are like major blow-ups that kind of happen? For example, the Celsius one blow up, or like something that really goes wrong, and then there is a case. So do you take it on as a service DAO, or do you like take it on as a this thing? What do you say in the non-profit angle?
Yeah, so it's important to clarify that then that the relationship between the client always with the professional, and so it's not with the association. The association is a go-to place in the sense that we are all shown in the directory of the association. We have our channels in which we discuss about legal developments. We publish also educational pieces. We try to make as much as possible partnerships with other organizations which are involved, I don't know, with company structuring or with DAOs or with accelerators. But that's it. Like when there is the need of advisory, in the end, what is made, an advisor is chosen. It can be one of a single jurisdiction, or it happens also that we work together as a team, and that's the beautiful part of the association. But basically, once like the client chooses the lawyers, the relationship is only between the client and the lawyers and not with the association. The association is just like an organization which is there to signal the presence of these crypto lawyers and to organize some events or educational pieces. You want to add something, Miguel?
No, exactly. Just to really clarify, we are not a global law firm or anything like that. There's no partnership between our members. Just a networking kind of partnership where we have no formal connection between each other, but informally we are all connected as directory. But that doesn't create any legal structure between ourselves, and the association ultimately is not engaged with any client. It's the members themselves that are engaged. That's basically it. So I don't see any issue arising with the association and any particular client, just because that there's no link there.
So what I find fascinating with what you guys are doing is that all these legal bills that you talk about, be it like now and what do you call the bDAO, a lot of the developments that's captured is purely about what's going on in the US. That's because a lot of the whole thought process, you see the legal developments that's happened in Wyoming and Colorado to some extent, and see that's where you see a lot of the major DAO developments coming in. That's where a lot of the whole legal aspects is coming. What I want to understand is why is it that there hasn't been a global coming together of these sort of lawyers to move the whole way in which legalization is taken up across countries? Money is no longer an issue. If you take a look at adoption and the money that's flowing in into major countries, it's South Korea, Asia, a lot of them have started picking up the pace. But when it comes to legalization, it's always been about the US. Your thoughts on?
No, you touched a very important point, and I think that's also like a value proposition of our association. But to explain a bit why we have this situation, which I totally agree is there, like we have a let's say centralized discussion, which is very focused on the developments of the United States. This is given by some reasons. First of all, because you're right, like now investments are coming also from Asia and from other parts of the world, but nonetheless, like the core of the money and of the finance is in the US, and therefore there is this very strong economic interest which drives a bit like also the legal problems. And in addition, like I would say that in the US, from a legal point of view, like the discussion is a bit more advanced than in other parts of the world, because they deal with this legal issues since the advent of Bitcoin, basically, whereas in some countries, basically people started to discuss legally about this problems in 2018 with the ICO boom. And so that's an issue. And I would say that Both situations are changing right now because of the investments coming also from other parts of the world, and because of the regulatory innovations that we are going to have very soon in many parts of the world. As for instance, in Europe with this new MiCA regulation, which is very interesting because it will impact the market as a whole, and so also the United States players. What is true is that given this advantage that was there in the United States, like these first organizations are pretty much driven by American lawyers, and so I refer to LexBank and XDAO predominantly. But I want to say, first of all, that they're open also to other nations and other backgrounds. But nonetheless, it's a matter like of majoritarian presence. Like you have a lot of Americans and not so many people coming from other parts of the world. We would like to change it. To be honest, I had a lot of experience with Indian startups, and I really understood like how many legal problems arise when you take the perspective of another country, and that not everything is in the US. And learned it with Polygon and the fascinating ideas that illuminated people had, enlightened people had over there. And so the blockchain lawyers group wants to be really a global organization open to every jurisdiction. Our aim is to have every single jurisdiction covered by the organization. This does not mean that, of course, we don't onboard US lawyers. We have very good US lawyers that are part of the association, and we're happy to have them. But we don't want to, let's say, focus too much on the US. We want to follow every development, because we think that every jurisdiction has some hidden advantages, and I think that every person located in every part of the world needs to have a proper legal advice concerning blockchain and cryptocurrency.
For sure. I think these problems arise not only in the US, lawyers applying from everywhere in the world. Like by the end of this month, we'll have all continents of the world but Antarctica. So if anyone is listening and he's a qualified lawyer from Antarctica, please reach out to us. We would be very open to have you on the blockchain lawyers group. But that's exactly it. I think these problems arise everywhere. I think the US is just like the bigger market, and they are more advanced in these talks than the rest of the world. But that doesn't mean that in other jurisdictions the same problems won't arise. We're just looking at to the US as the leader in this field, but with MiCA going into effect in Europe probably next, we'll probably see the rise of an extraterritorial effect on the European regulations also to the US. So the US must also be very attentive to what the EU is doing. So as Francesco said, our purpose is global because, as we mentioned earlier, these matters are all cross borders. You always need local counsel advice somewhere else in the world. And so lawyers, to better advise their clients, they need to be attentive to these developments mostly everywhere, not just in the US. So I think that the fact that the US is a leader in this field, and if we are just attentive to the US, we'll miss a lot of things happening outside of the world. And US lawyers also have to look outside of their market and understand what's happening elsewhere so as to advise their clients. So I think the paradigm is definitely changing.
I think that's pretty neat. You take a look at what's going on. This is speaking from an Indian perspective. A lot of the laws that are shaped, especially from the crypto side of things, or even technological, how they make those laws, they study what's happening in the US. I think this is a common practice in every country. They study the laws that exist in every other country, and they shape it to what's working out for their political constituents. And the thing is, the US has always been that benchmark when it comes to figuring out the whole laws itself. In 2018, we were supposed to have come out with a ban that was going to ban crypto in 2018. And when you see the bill that was going to be passed in our main house, the Lok Sabha, it didn't cross through. But what happened was, if you see the footnotes, they have studied the law, the sort of legal discussions that was happening in the US, in Japan, and South Korea to some extent. These were three countries that they were looking at in 2018. And it's pretty fascinating that you're trying to set up the foundation, not a foundation, but an association for these lawyers to understand what's going on in every country so that they can make it work for their clients that way. Begs another question though. The way US is moving forward with developments, the way you see it with Estonia, it's not the case globally. It's the whole DAO aspect. I think there's zero discussion going on about the whole DAO side of things in India, in major parts of the globe right now. But it's only happening in the US. Which other parts of the globe do you see that sort of with respect to how DAOs should be regulated? I can see that for the Near Foundation, they've had something set up in Switzerland. Estonia is also one of them. What are the other countries that's like actively being haven of discussion for these sort of developments?
Yes, I think that the discussion can be made in several levels because we know that there are some jurisdictions that seem more friendly to DAOs, but we have to be aware that the legal solutions that are adopted, you mentioned, for instance, Switzerland, and we know that like foundations are quite often used as a tool like to wrap a DAO or to represent a DAO. Like these instruments were not made for DAOs. So we have some kind of adaptation of the existing structures for DAOs. What is missing so far, and that's a bit the challenge, which at the moment is really important in the US, are regulation concerning DAOs, which is the liability of the members, what is exactly a DAO, how can you determine if a person within the DAO is liable or not. And I have to say that in Europe, for instance, this developments are not so followed so far. In this regulation that I've mentioned before, the MiCA, DAOs are excluded. They are excluded, so it is stated the organization is decentralized. MiCA will not be applied. It must be fully decentralized, so the legal problem will be to understand what does it mean, when do we have this full decentralization. But nonetheless, we know that for some time it will be totally fine, or it must probably be totally fine, because we don't have clear rules, and so it is probable they will not going to fall within this new set of rules. Whereas in the US, we had a dramatic acceleration. You mentioned it before, like the Ooki case is a case which is really like scaring a lot the industry, because what happened is that DAO was sued, and it was sued simply by posting like the notification of the beginning of the claim within the social media of the DAO. And this is something which really never happened before. There were a lot of ongoing discussions concerning are the people in danger, the people that are part of the DAO, but we hadn't a case so far, and so it was just as a discussion level. But now in California, we have a pending case concerning a DAO, which is this OokiDAO, and therefore there is the need really to trying to frame a bit who can be liable within a DAO, because like the first idea of the American authorities, it's stating everyone who voted within the DAO can be held liable for the operations of the DAO. And the problem in the Ooki case is given by the fact that Ooki performed a service through its platform, which is regulated in the US. You need an authorization to do it. And therefore, like not having this authorization means that you are subject to fines. And theoretically, the persons that are part of the DAO could be held liable and also be obliged to pay fines, which is not beautiful. And so what's happening right now is that basically nobody of the DAO is stepping in the process, so responding to the claim, but two organizations take the position of the DAO and acted into this process as so-called amicus curiae, which means basically an expert which jumps into the process and that tries to advise the judge to give a certain direction as an expert. And who did this? Lexbank. So Lexbank is taking really an important role in the industry. And also the DeFi Defense Fund, which is another organization which was funded by Uniswap like the last year. And they entered into this process in trying to indicate to the judge that it's not possible to sue a DAO in the way that they've done, because they don't have a proper notice. Like the people that are involved in the DAO do not really know if they are part of the DAO or not, because it's something which you have to determine on the basis of several different elements. And therefore, what has been stated by Lexbank is, look, you cannot notify this to a DAO without indicating which are the parameters to create liability. Who are the members that should be, let's say, considered part of this process? In not clarifying this aspect, you are infringing like very important rights which are recognized by the constitution, because you are eliminating the possibilities for people to exercise the right of defense. And this is something which really everyone should consider and follow, because depending on how this process will end up, there will be a new DAO landscape, legal landscape, which will be basically a benchmark that everyone will need to consider. And so it's very important to follow.
For sure. For now, what we've seen is very creative lawyering when it comes to DAO structuring, whether it's in the Cayman Islands or the BVI or in the US where DAO regulations are already put in place, or Switzerland or Estonia, as you mentioned. We've seen, or Guernsey, I've also seen Guernsey. You see a lot of DAO structuring that is creative so as to avoid liability on the members of the DAO, because if not, you are entering into a general partnership which the members have unlimited liability for all debts that arise from the DAO. And also, in this case, you need a regulatory authorization to pursue a determined activity. And if you don't have it, I mean, that's where the unlimited liability also comes in. So as Francesco said, and rightly said, these cases will set the pace for what the industry will be like. And that there's clearly no regulation in Europe right now. It's all Wild West. So that, as I said, creative lawyering is effectively what's happening, and different structuring to understand what would be the best case for each different DAO. But ultimately, we are unsure if you have, because this is all new. So you have tokens and you have governance rights in the blockchain governed by smart contracts. So this is all very new. This is very cross borders. There's no certainty whatsoever. So once again, we're looking at the US to see what they come up with, what their solutions are, and understand whether it makes sense or not to be globally adopted. But yeah, certainly looking forward to see what these cases will become.
The way this is a very good segue. We just want to get into the broader DAO side of things, because you mentioned that when this brief was filed, the question was, who exactly is a DAO member? According to the lawsuit, it's like the people who voted in, they are considered in as a member. And LexPunk's argument is that you have not defined who actually could be a member. So how can you just go start suing people on the basis of just voting when that whole regulation is not there in the first place? But the way DAOs are marketed right now, it's like decentralized autonomous organizations. Whoever is part of the Discord, the whole 6,500 members, they're all part of the DAO. Maybe they may get to vote, maybe they're not. But that also is another level. The whole Discord side of things, you have whether you're a member in the DAO, or whether you can vote in the DAO, or probably you're in their Commonwealth forum. The way the DAOs marketed, you have that number being counted as members. But when you go to the lawsuit side of things, that whole spectrum kind of becomes very this thing. And this is what happens when you don't have that sort of structuring that is done on the basis of a legal wrapper. The DAOs, the way they've done it so far is they've not like really considered it, except for a very few couple of DAOs. It's the general landscape has been very apathetic towards the whole concept of legal wrappers. So my question here is, if DAOs really didn't care, this is a development we are seeing in the DAO space in US. What exactly is in store for these people if they don't like start caring about having these sort of wrappers in place? And what exactly is the definition of being a member?
Yeah, that's a very good point, and I think that in the end of this case, we are going to know more about this definition. I think that we cannot adopt a too broad definition, and because obviously, like if you are, for instance, you have a governance token, you've voted 2 years ago, and that's the problem in this case. And you voted 2 years ago, you never went into the social media platforms of this organization. Perhaps you don't even know that someone has sued the DAO, and so that you are concerned. And so this is why it's a bit crazy to consider that you can sue someone in this way. And that's the argument of LexPunk, because they say, okay, you want to sue something, you have to go against the persons. You need to let us understand who is involved, because people need to know in order to protect themselves. Because if you don't know, like for instance, I could be a voter of OokiDAO. Am I concerned or not by this claim? And so this is very important. And this, of course, leads to the main problem, which is understanding, is it better to have a wrapper or not? And here I have to say that the industry has not like a clear indication, because some lawyers think still nowadays that it is better to have a completely decentralized digital organization where you don't have a single point of failure, and therefore you run the organization with the tokens, which are split all over the world, so that it's not possible basically to indicate who is responsible for the operations of the DAO, which is completely decentralized. Then, of course, there are some key things within the DAO that you can protect more through, for instance, companies that act as service providers for the DAO. You could think about wrapping a sub-DAO, but this is a solution which is adopted also by very known DAOs, as for instance, and also Balancer works like this in the moment. And so we have to see. I think that this picture can change a bit depending on how this case in California will turn out. Another option would be like to incorporate a wrapper, and some people argue that this is basically limiting the decentralization of the project, and so that it's not fine. Also here, I don't want to give, I don't give legal advice, but I think that in the end you have an additional layer of protection for the people. And I think that the goal of everyone should be like not having the members of the DAO involved for the operation in liability issues. And therefore I think that a wrapper can make sense, because then if something goes wrong in terms, I don't know, of hackings or triggering some sort of liability because of regulated activity, I think that the first basis to attack would be the wrapper and not like the persons which are behind the wrapper. But of course, this is just a pre-estimate that some people do, because we don't have case law so far, like in indicating that, I don't know, the authority in the US would go against the foundation instead of the persons within the DAO. What happened, for instance, in Ooki, it's a very peculiar case in which we had an LLC that then got transformed into a DAO. And the presence of the LLC with the two founders was, let's say, very significant also with the DAO. And so this has some peculiarities. And in this case, like they went against everyone, LLC plus DAO. And so it's difficult to really to guess what would happen in a case in which we have a wrapper as, for instance, a foundation.
Exactly. It's very unclear, and that's the question I think we're all looking for a solution to. Is it's very unclear to understand who should be liable within the DAO, and what is a member and what should be qualified. If I enter into the Discord, am I a member, or am I a member if I work, or am I a member if I work and vote, but what if I just buy a token in a centralized exchange? Am I also a member? There are a ton of questions that we are still looking for an answer to. We are very expectant to see what these cases turn out to and what are the solutions here. I think all of these questions will be posed. I'm not sure if we're going to have an answer for all of them, but if we have some clarity going forward, then that's going to be beneficial for the industry. Even if it's a hard stance, we will know and we'll have certainty, a little bit of certainty on what to count with.
If you were to take the side of a prosecutor on this one, a lot of these DAOs have gone in with the notion that all DAOs are digital nations and the members within those certain DAOs are like citizens and all of that. And when you see the concept of a nation and a citizen itself, most citizens don't vote. But the fact that they are within that jurisdiction also, along with that of being called a citizen, they are all actually considered a citizen, even if they're not considered a voter per se. And if you take a look at the way, if DAOs call themselves nation states in some way, the fact that you have people within the Discord itself and they're not voting, you can put that argument out there that you've considered them as a part of the whole community. And if you're going to call yourself a nation state, then you may have some problems there for those who may not vote, or those who are not part of the operations, just like a government, just like a voter. But you're still a citizen and you may fall under that category. My question is, when you step back and see the whole aspect of, could there be this possibility that I see with the OokiDAO angle, that what happened here is that the lawsuit went after everybody, not just this main foundation itself. And because there's so much legal confusion, because there's no legality set per se, I see a lot of problems for the broader community, because if you have an adversarial team who doesn't care about the community and who just wants to rug the community at some point, even though there is this what do you call this facade of decentralization where everybody tends to have some sort of control, but in reality it's the core team that has the control, that takes the main decisions. But DAO, and when the time comes that there's some sort of rug, it's like unlimited upside for the core team, but limited downside in terms of legal issues, because you have the broader community also coming into play. Do you think that scenario could be plausible with this?
I think what we are assuming here, and for the last 20 minutes or so, we're talking about DAOs, we're assuming these are actually decentralized, so that there are various people who can influence the decisions, and not just a few members or key members who are the key deciders or who are able to influence the DAO's decisions. And Mika takes a very good, I think, a very interesting stance on that, and excludes DAOs which are decentralized. But if you just call yourself a DAO and you're not really decentralized, you're going to be looking into a centralized kind of organization, and you have someone who to point to, and you're entering into a general partnership, and then you're just within the law which is already enacted and which you can be liable to. So in that situation, if you can point to someone and say, oh, they effectively control this organization. This is not decentralized at all. These are the people who are going to be liable in the end. I'm not sure. This is all just speculation, and none of this is legal advice. Of course, it wouldn't make any sense to have these decentralized people who may have a governance token, but in the end, they have no voting power, have no decision making power. So there's no sense in holding them liable as well. So what I believe is pure very decentralized. There's no issue on having like rug pulls from a core centralized team if everyone is voting on the decisions and it's the rule of the majority. But yeah, that's how I think regulators will try to approach them. It's if you're truly decentralized, you may fall outside of the scope of regulation, but if you are not, if you're just calling yourself a DAO, that's more problematic for you.
Yes, I want to add something because, for instance, I think that you're referring also at the situation in which we have bad players within the DAO. I think that in this case, it's important not to consider the DAO as a kind of shield for liability. If there are bad players, which I don't know, empty the treasury of the DAO through transactions, of course, there you go against these persons that are liable on a personal basis. And this is something which should remain. And I think that also our way of presenting like legal issues and regulatory solutions must always bear in mind that if there is a bad player or someone who is not playing according to the rule, the law must be enforced in a way which is very strict, also to give credibility to the industry as a whole. What we don't want to achieve is the fact that basically regulations do not take into consideration the peculiarities of a DAO, and so stating that every person that voted within a DAO can be held personally liable for what the DAO does is, to me, a bit absurd, because it really can be something which blocks the development of technology. And just to leave a note which is not so pessimistic, I think that we have to take into consideration the different types of DAOs. So there are a lot of social DAOs which do not pose so many dangers from a legal point of view. Of course, if you deal with a protocol, a DeFi protocol, the history is different and you have to take special, let's say, solutions and be careful about what you're doing. And there, the decentralization is very important. So the best possible outcome would be to have a protocol which runs in a way which is completely autonomous and on which the people cannot impact in any way. If you give the possibility to update smart contracts, to administer smart contracts, there will be always some person that may be held liable for the operation of the protocol. And that's pretty much the case. And so there you need to have this not having the possibility to modify the smart contracts, which is, for instance, the case for Uniswap. And then have this fair amount of decentralization, how much as possible, in order to demonstrate that basically nobody is really in charge for what the smart contract does. And then this should be, I think, the goal for now. Then if we will have other regulations, we're going to manage this aspect in a different way.
I feel that you mentioned that DAOs should be decentralized enough and there should be distribution of autonomy across the community to prove that decentralization and ensure that, okay, if you're under that wrapper, then that sort of liability does not come to the broader community itself in the eyes of the law. But you see the DAOs itself that's tried to come under the legal wrapper itself through the foundation or whatever. These DAOs, they are scaling up their communities. They want to structure how things are done. And you have the concept of sub-DAOs coming in the scene where it's not, now you no longer have one major autonomous organization. You have multiple independent autonomous organizations underneath. And they are also very much capable of seceding from the DAO if the broader collective is okay with that. What does this mean for the broader legal viewpoint itself? Does this mean that if I am Gitcoin DAO, for example, and I have 5 independent work streams underneath me, does that mean that if I call myself an autonomous organization underneath, Do I need a legal wrapper also? Does every so-called organization that has a multi-sig, that has some sort of control coming into play, do they need their own legal wrapper?
Of course, it depends a lot how risk adverse the persons are. Because, of course, if you are super risk adverse, then you want to protect yourself through a shield for your own liability. If you manage a multi-sig, then you're always subject to some sort of liability. Of course, it's difficult that it gets hacked, but imagine that it happened. Theoretically, the funds are not necessarily yours, and so there is some risk of liability. But in any case, like you mentioned it before, the sub-DAO structure, I think it's a good way of giving an additional, let's say, push towards decentralization, because you give the idea that there are different points in which decisions are taken. And then depending on the, let's say, danger of the activity that is performed by the sub-DAO, you can think about different legal solutions. And so if, for instance, there is a for-profit activity or an investment sub-DAO, which can be part of a broader organization, there you create a proper legal wrapper, also in a form of an investment vehicle close to what happens in the financial world. And in this way, basically, you segregate the danger for the whole organization in having a legal wrapper there. And I think that for very big organizations, this is a good solution, because depending on what you want to achieve, you basically frame a legal structure which protects the persons that are involved in the sub-DAO, and plus it protects also the rest of people, because if something goes on, then it does not affect the rest.
No, for sure, totally agree. And I think one of the questions is, at what point you have a sub-DAO, right? Only like a multi-sig, so you have a multi-sig and then you have a sub-DAO. What does it effectively mean? And from a legal point of view, that's not clear at all. So there's a lot of questions there. As I said, and as Francesco said correctly, so the problems the sub-DAO and the DAO poses are very similar. The fact that they're within a structure just makes it a little bit more complex. But every consideration that we've spoken so far, it applies mutat to sub-DAOs for sure.
Absolutely. I think it makes a lot of sense that way. Who do you think are the best when DAOs you look to in that sense? Which DAOs are like really setting the benchmark when it comes to having that sort of, at least taking the right steps with respect to having the legal wrapper and ensuring that the community is protected? Which, if you are a community and you want to assess that, okay, these guys have done their thing in a suitable way, who's doing the right sort of work that way?
So I think it depends pretty much on the nationality of the founders, on the activity which is performed. So it's difficult to state like one solution which is best for everyone, if it's non-profit or for profit. In any case, from what I see, a model which fits very well, which is not like the model which was created for DAO, is the Cayman Foundation. Because of its inherent peculiarities, it gives a lot of flexibility also in the framing of the articles of association. It is possible to create a connection between the token holders and the governance of the foundation, which is very nice. And plus you have a jurisdiction which is quite friendly, although new rules will be enacted soon concerning also AML. It's becoming more serious, and I think this should be welcome. But they have also a very flexible legal systems. A very flexible structure of the foundation, plus a friendly legal system towards crypto. And so I think that today this is a very good solution if the DAO involves some sort of legal risk. Otherwise, I'm super keen also to adopt structures in other parts of the world. We talked a lot about Wyoming DAOs, but there was a lot of discussion, but only because the name was used, like DAO, LLC, DAO, DAO, LLC. And so there was a discussion. It was also a US state, and this also draw a lot of attention to this kind of structure. But for instance, if it's a non-profit, it is fantastic also to use this in the EU. For instance, we have our French member of the blockchain group that has formed many DAOs in France and using the French association, which is very similar also to other forms of association that we have in Europe and also in Switzerland. So it pretty much depends on the goal, but for very broad DAOs that have, let's say, financial risk, etc., I think that the Cayman Foundation is a very, very good solution. Other solutions are like trusts. For instance, the Guernsey Trust is also something which is adopted, in which you don't really have an entity. It's just the patrimony which is used by the trustees for the beneficiaries. There is an enforcer who takes care that the goal of the trust is fulfilled. although here, like, nobody really knows if this would cover the liability of the members of the DAO. And so it's something which works out quite well, but we have always to bear in mind that it is unknown what would happen in cases of claim against the DAO and against this types of entities or organizations.
For sure, I don't want to go over time, but it's exactly that. We've seen a lot of cases which have been thought of and been been structured by lawyers who do understand the legal intricacies here. And going back to Blockchain Lawyers Group, that's just what we intend to do. We intend to just go over this first step of understanding what a DAO is, what's the legal problems, what has been done in other places, so you can just talk to a qualified lawyer in a given jurisdiction. It can just point you to either the Cayman or Guernsey or BVI or Switzerland or France or Estonia. And it all depends on effectively the personal situation and what they intend to do. So yeah, that's going back to the beginning, I think it's just exactly that, with the bridge we're trying to cross. And for now, on these last 11 days since we've launched, I think we've done a pretty decent job.
I really feel that there's a lot of good insights here for people who are looking to explore the option of legal wrappers and why it matters. If you are a community and you want to be able to connect with traditional banks or organizations, you need to have some sort of legal existence to set up that sort of contracts. If there are community people who have some sort of issues, how are you going to like deal with the DAO in a court if they're not having that sort of existence? So as a community, it is necessary to ensure that there is a legal wrapper put into place. And with what you're seeing with OokiDAO, if you don't have a wrapper set in place, unnecessarily your members will just come into a lot of legal liability for nothing. So this is a major development that communities across the globe must be thinking about, because the US is the harbinger of the sort of legal developments that can come across the space. And we need people who are working across, who understand what's going on in the US and are able to educate people across the globe about how to allow for DAOs to be accommodated in a way that makes sense for the country as well. And you have DAOs thriving also. And none better than these fine gentlemen and the initiative over here. It's been a pleasure to have had you on this call. I know that there is a lot we could have gone on for hours, but this is the best we could do. A real pleasure to have had you guys. Where can people follow you, your initiative, and how do we start finding out lawyers, man? I think I should get out of some Discord servers now.
A pretty easy way to reach us is through our website, which is called blockchainlawyers.group. So you have the directory there. You can also speak directly to one of our members. That should be fine. We have also our Twitter account, a LinkedIn account, and also our Discord, which is also available on the website. So if you're looking for a lawyer as well, you can just go to our Discord and just go to find a lawyer, and that's it. And also follow us on Medium. We do publish a lot of articles there, so we also have that.
And we'll have all the links posted about both Eagle and Miguel on the descriptions. So if you have any sort of legal advice, do stop by. Since they are part of the episode, I think it'll be safe to call them our in-house lawyers, but okay.